This video is our third video about the effects of rights in REM on third parties when it comes to unregistered land. And we've looked at the position before the 1st of January 1926, which effectively relied on the Doctrine of Notice. And we've looked at the position after the 1st of January 1926, which was a set of legislation that looked to replace this Doctrine of Notice and the uncertainty of that. And in effect, we had the land charges registration, and we also have this concept of statutory overreaching. And it's this second part, statutory overreaching, that was introduced in 1926 that we are going to look at in this video. Such an equitable interest subject to statutory overreaching is the beneficial interest under the trust. And we said before that the beneficial interest under the trust cannot be registered as a land charge under section 2 subsection 4.3 of the Land Charges Act 1972. They're not dealt with under the Land Charges scheme, and they are not governed by the Land Charges Act 1972. Instead, their impact on a third-party transferee is governed by the doctrine of statutory overreaching, and also in part by the pre-1926 law. So let's make sure we understand the different trusts, because of course, as you know, the beneficial interest under the trust is the main part, such a core concept when it comes to statutory overreaching. We must make sure we understand trust, at least in its basic sense, at this part of the course. So here we have a trust of the freehold estate in land, and this is the simple trust, the simplest form of trust, where we have one trustee and one beneficiary. So we have a trustee who is the legal owner of the freehold and holds that property on trust for a beneficiary, for someone else who is the equitable owner of the freehold. Then there's like another form of trust. So this is slightly more complicated, but instead of having one beneficiary of that trust, you can have two beneficiaries of the trust. So it could be split up, let's say 50-50 between the beneficiaries, or here we've got the example of 75-25. We could have a trustee who holds a property or holds some money on trust for two separate beneficiaries. So we could have a pot of £100, and £75 could be for one beneficiary and £25 for another beneficiary. Okay, so it's a slightly more complicated trust, and there's an even potentially more complicated trust as well. We have not just two beneficiaries, but also two trustees who are joint legal owners of the freehold. So there could be overlap between the trustees and the beneficiaries, and in fact the two trustees could even be the two beneficiaries. So they may be even the same people, and that is actually often the case in land law. But don't worry too much about that. Just understand the concept for the minute that you have trustees that hold the land on behalf of the beneficiaries, and in some circumstances, and certainly in land law, it may be the case that the trustees and the beneficiaries are just the same people. So the beneficial interest under trust is an equitable right in rem. In other words, it is a right recognised by equity capable of binding third parties. Beneficial interests under trust are therefore capable of binding a transferee of the legal freehold. So the trustee holds the legal freehold and transfers it to the transferee. The beneficiary has the equitable right in rem under the trust. What impact then does that right in rem have on the transferee of the legal freehold? Okay, so in this little diagram, if the trustee sells the house to someone who purchased the legal freehold, and there's a beneficiary of the trust of that property, say, how does that bind the purchase of the legal freehold? How does that trust bind them? However, were the beneficial interest under trust actually to bind a purchaser of the legal freehold, the purchaser would himself become trustee of the freehold and obliged to hold it entirely for the beneficiary's benefit. So that would be an enormous burden on the transferee. If, let's say we had a trust and that was always going to bind the transferee, then, they wouldn't be buying any sort of, they wouldn't be buying a right to enjoy the property themselves, they'd be buying the right to hold it for someone else. So while a satisfactory outcome for the right holder, the trust beneficiary, this would be, most unsatisfactory for the purchaser, as they would effectively receive and achieve nothing of value. So the 1925 property legislation therefore aimed to effect a compromise between, on the one hand, the interests of the public in securing that land, in securing that land in trust is freely marketable, and on the other hand, the interest of the beneficiaries in preserving their rights under the trust. The law recognises the beneficial interest under a trust is a right in rem, but the law tries to control the circumstances in which this right in rem, which is capable of binding, actually does bind, because the consequences of it binding are so substantial and so damaging. So this is why you don't see the beneficial interest under the trust in the Land Charges Act, and why it's not included in Section 2. The effects of Section 2 of the Land Charges Act 1972, automatically binding equitable rights in rem, would not be an attractive outcome for this particular right. But at the same time, the law wants to offer protection for the rights holder and ensure the beneficiary under the trust has some property right even after the sale. So how can it do it? And this is where the doctrine of overreaching comes in. This comes in to save the day. So this compromise effectively was achieved by statutory confirmation of a doctrine of overreaching. So let's have a look at this concept of overreaching. Now, overreaching operates to detach beneficial rights under trust from land on transfer so that a transferee cannot be affected by them. So this is how it works. On a transfer of a trust of land, the beneficial rights under the trust detach from the land, which means the purchaser cannot be affected by them. So the purchaser of that land will take free from the beneficial interest under the trust. The rights, however, then reattach themselves to the replacement property that the trustees, the legal owners of the freehold, receive from the transferee, and that will usually be money. Okay, so this property becomes the trust property in place of the land. So if you have land, and this is under a beneficial interest under the trust, and then that land is sold, the purchaser of that land will get the land and they'll be happy as Larry. They can do what they like with it and they can enjoy the benefit of that land. But the money, let's say, that is received from the sale of that property or that land will therefore become the trust property itself. Statutory preconditions of overreaching. A conveyance to a purchaser of a legal estate and land shall overreach any equitable interest or power affecting that estate, whether or not he has notice thereof, if the conveyance is made by trustees of land and the equitable interest or power is at the date of the conveyance capable of being overreached by such trustees, and the requirements of Section 27 of this Act respecting the payments of capital money arising on such conveyance are complied with. Okay, so this may be a little bit wordy, but this is contained within Section 2 of the Law of Property Act 1925, and it says the equitable interest must be capable of being overreached, and this requirement restricts overreachable equitable interests to beneficial interests under the trust. For example, your equitable easement or restrictive covenant is not capable of being overreached. That's all that is really saying to us. Okay, the proceeds of sales or other capital money shall not be paid to or applied by the direction of fewer than two persons as trustees. So Section 27 of the Law of Property Act 1925 says that in order for an equitable interest under a trust to be overreached, the capital money arising from that must be paid to two trustees. And we saw earlier that it was possible for there to be two trustees or more of land. So let's look at a diagram of this. Okay, so have a quick look at this diagram, and we can see that T1 and T2 are the trustees who own the legal freehold of land, and they hold the legal freehold on trust for A and B. So there is a beneficial interest under trust divided into two portions, A holding 75% and B holding 25%. The trustees then sell that land to the purchaser. At that point, the beneficial interest detaches from the land and does not bind the purchaser. They then reattach to the money which T1 and T2 get for the land. So the beneficial interest under trust is reattached to the money in the hands of trustee 1 and trustee 2, the two trustees. Okay. So it is transformed from a trust of money to a trust of land. So A and B have a right in rem over the money, and the value of the interest has been preserved by the doctrine of overreaching. Okay. So the residual category of equitable rights in rem. A continuing role for the pre-1926 law. Now, some equitable rights are neither capable of registration as land charges nor overreachable. So we've really said about the whole equitable rights are really fall into these two main categories of being land charges or being, having statutory overreaching. But there is some equitable rights that aren't capable of either of these two things. Okay, and the impact of these rights on third parties continues to be governed by the historical notice rule. So the right binds every subsequent transferee, that the right binds every subsequent transferee except a bona fide purchaser for value of a legal estate in land who had no notice of the right. So today, the number of rights that fall into this category is very, very small, arising in untypical situations. This is basically a hole in unregistered conveyancing. This is the reason why we still need to know about the notice doctrine. It still does apply in some limited circumstances. Such examples would include equitable co-ownership interests behind a trust of land and equitable successive interests under a Settled Land Act settlement. Also pre-1926 easements and covenants and pre-1926 Class B and C land charges. And there are a few others, but as you can see, they're very particular situations where this doctrine of notice would still apply. So we got this case of Kings North Finance Co. Limited and Tizard 1986, and in this case there was a husband held a legal freehold on trust for himself and his estranged wife. The husband lived in the house with his two children. His wife visited daily to cook meals, and so on. Now the husband secretly granted a mortgage of the legal estate to Kings North Finance, having arranged the mortgage inspection when his wife was out of the house. Kings North Finance paid the mortgage money to the husband alone. As Kings North Finance did not pay the mortgage money to two trustees, the wife's beneficial interest was not overreached. The question of whether the wife's beneficial interest bound the bank therefore fell to be determined by the doctrine of notice. The obvious presence of children in the house should have alerted Kings North Finance of the need to make further inquiries as to possible rights of a wife or partner. So Kings North Finance was therefore fixed with constructive notice of the wife's beneficial interest under the trust. So you can see how the idea of notice came into play in this obviously post 1926 case. So it's applying pre-1926 law to a post-1926 case. So that's an example of where notice is still coming into effect and still plays a limited role. So rights in rem post-1925. So very briefly, there are four groups of proprietary interests in unregistered land conveyancing. We've got legal interests, which always bind, and we've got equitable interests, which are rights that are registrable under the Land Charges Act 1972. We've got equitable rights or interests that are not registrable under the Land Charges Act 1972 because they are subject to overreaching. And we've got equitable rights that are not subject to either the Land Charges Act 1972 or overreaching. Thus, they are to use still the doctrine of notice. So this little chart here should give you a good overview of how legal and equitable rights in rem still work and still bind when it comes to unregistered land. So these 3 videos on unregistered land should really help you to understand how rights are still able to bind third-party purchasers or transferees of the land, and trying to understand the equitable side of rights in rem can be quite difficult. So if you do have any questions about that, just leave me a comment below and I'll get straight back to you. And make sure you subscribe so that you can get updates about my next videos. Thank you very much for watching.